In the U.S. Supreme Court in 1954, there was a case that had reached the Supreme Court called Tehitan Indians versus the United States. And in that particular case, it had to do with timber in the Tongass National Forest and given to a particular logging company by the Department of the Interior. And the Tehitan Indians sued for compensation, saying that their timber had been taken from them without a right on the part of the United States. The U.S. Justice Department sent a legal brief to the U.S. Supreme Court in that case. And the main argument of the Justice Department was the Christian nations of Europe having located and discovered the lands of heathens and infidels. And the U.S. Justice Department also cited Genesis 1:28 and the book of Psalms and the Old Testament.
And God blessed them, and God said unto them, Be fruitful and multiply and fill the earth and subdue it and dominate the fish of the sea and the birds of the sky and every animal that creeps on earth.
And use that and this reasoning about Christians and non-Christians as the basis of its legal argument in Tehitan. In the following year, 1955, the majority decision in Tehitan was written by Justice Stanley Reed. And Stanley Reed had written a dissenting opinion in an earlier case called Alcy Band of Tillamook's. And in that particular case, Stanley Reed said that the theory put forward in the Johnson ruling was that discovery by Christian nations gave them sovereignty over and title to the lands discovered. He used that exact same reasoning in the Tehitan ruling of 1955. And so when you look at that, you'll see that he cites to the chapter in Henry Wheaton's Elements of International Law. According to the European ideas of that age, the heathen nations of the other quarters of the globe were the lawful spoil and prey of their civilized conquerors. He further said, it thus became a maxim of policy and of law that the right of the native Indians was subordinate to that of the first Christian discoverer, whose paramount claim excluded that of every other civilized nation and gradually extinguished that of the natives.
United States Court of Appeals, Ninth Circuit, San Francisco, California.
On August 27, 2014, a three-judge panel of the Ninth Circuit Court of Appeals in San Francisco demonstrated a contemporary application of the Doctrine of Discovery and the Johnson versus McIntosh decision. They did so in a case regarding the Kumeyaay Nation ancestral remains in California. In its decision, in White versus the University of California, the Ninth Circuit panel said that the Kumeyaay Nation has only an aboriginal interest in the lands it occupies. As the court stated, aboriginal interest in the land generally is described as a tribe's right to occupy the land. It is not a property right, but amounts to a right of occupancy, which the sovereign grants and protects against intrusion by third parties. Tehitan, Indians versus United States, 1955. That right, which is residual in nature, comes from the legal theory that discovery and conquest gave conquerors the right to own the land, but did not disturb their tribe's right to occupy it. As recently as 2005, the United States Supreme Court applied the Doctrine of Discovery in footnote number 1 in the case City of Sherrill versus Oneida Indian Nation of New York, written by Justice Ruth Bader Ginsberg. Under the Doctrine of Discovery,